All right, with that, I'm just going to give a short introduction to what we're going to go through today before we get into our speakers. I do want to note that starting last fall, when the draft MEPA regulations were being circulated in finalized form, EBC and more specifically the DEI committee intended to hold a kind of nuts and bolts program like this to provide practical insights to practitioners, developers, and interested parties to understand how the new environmental justice regulations and protocols work and what applicants need to consider and address as they move forward to assess and evaluate compliance with the new requirements. I'm grateful for the opportunity to work with Valerie Moore from Nutter and the EBC staff, particularly Ann and Jackson, to help coordinate this program. And we're pleased that we're able to do this so soon after the regulations being promulgated. We've got a couple of great speakers today. Tori Kim will be first. She's the Assistant Secretary for the Executive Office of Energy and Environmental Affairs and the Director of the Massachusetts Environmental Policy Act Office. An attorney by trade, Tori started in private practice at WilmerHale and then held a series of government positions, including at the AG's office and the Executive Office for Administration of Finance, and later as General Counsel at EEA. We appreciate EEA's willingness to make Tori available for this forum today. And by the high attendance that we have today, it's clear that there are many people who want to be informed about the proper interpretation and application of the new EJ regulatory requirements. And it's really a benefit to have Tori's expertise and intimate knowledge of the regulatory process as part of the program today. I will note that as we've said a couple of times, there is going to be a moderated discussion at the end. And so please hold your comments for, hold your questions for Tori until that time, but you can get them into the chat as they occur to you. And with that, Jackson, I think we can turn it over to Tori. And Tori, thank you again so much for your efforts in being part of the program today.
Yeah, great. Thanks so much, Peter, and thank you for the introduction, and thanks to EBC for the presentation, for the opportunity to present today on the new regulations promulgated by the MEPA office. So as you know, the regulations were promulgated in December of last year, and they are an important first step in implementing the new requirements relative to environmental justice included in the climate legislation that was signed by Governor Baker in March of 2021. So I'll be using a slide deck today that we compiled upon the completion of our regulatory effort in December, hence the date on the slide deck. It is already posted and available on the MEPA website, so you can grab it that way, and I think EBC will be circulating it as well. The slide deck reviews key components of the climate legislation as related to the MEPA review process and describes how those components have now been incorporated into both our regulations and two new protocols that took effect on January 1, 2022. So I also would like to take the opportunity today to thank EBC and all the members of the MEPA Advisory Committee that was formed in September of last year to provide broad stakeholder input into our regulatory effort. The committee has truly been an invaluable source of both historical knowledge and innovative ideas for future revisions. So I anticipate there'll be a robust Q&A today after my presentation, as you noted, and I very much appreciate the large turnout by your members. So I'll attempt to go over the slides relatively quickly so attendees will have a good chance to ask a lot of questions today. Next slide, please. So as many are aware, MEPA actually launched our regulatory review effort in February of last year, even before the climate legislation was passed. We outlined as our primary goal alignment with state policy and planning efforts in three key areas, which always included environmental justice. However, given the passage of the climate legislation and the tight time frame of the end of 2021 that was imposed on the MEPA office to promulgate regulations, our focus very much shifted to implementing those legislative mandates by the end of the year. Now that we've completed our first phase of regulatory revisions, we do intend and are already engaged in what we're calling our phase 2 regulatory review effort that will look at the entirety of MEPA regulations. In addition to reconvening the MEPA Advisory Committee for this purpose, we are also partnering with Mass DEP, the Department of Environmental Protection, on a parallel effort to develop what's called a cumulative impact analysis approach, or CIA, to air permitting. This was also a mandate that was imposed on Mass DEP under the climate legislation and may result in methodologies that could be used to refine the EJ protocols that we issued this year and that I will discuss later on in the presentation today. Next slide, please. So just to start off, this is a quick overview of the basic rules of MEPA, which many of you are very familiar with. Of course, the key requirement that triggers the need for MEPA review is twofold. One is the requirement of an agency action, which typically is a state agency action, typically a permit action, and the project must meet or exceed certain review thresholds that are set out in regulation. So these are levels of environmental impacts that determine the level of review. So a higher level impact will typically require a higher level of review through MEPA. The core requirement of the climate legislation essentially changes the familiar dichotomy between the so-called ENF level review, which is typically a 30-day review process upon the filing of an ENF or an environmental notification form, and the lengthier EIR review, which begins with the filing of an ENF and that 30-day review period, but then extends to 2 additional rounds typically of review based on the filing of draft and final environmental impact reports, or EIRs. So the key change that's made through the climate law, as I'll explain in a bit, is that for projects located near EJ populations, it is now an automatic EIR review for reasons that I'll explain throughout the presentation. Next slide, please. So moving on to the key sections of the climate legislation, there are 3 key provisions that address the MEPA review process that are now incorporated into our rules and regulations. First, Section 57 of the law requires that all projects that are submitting EIRs now address public health impacts of the project in addition to environmental impacts. So this is now a requirement for all EIRs, regardless of whether the project is located near EJ populations. Next slide, please. So next is Section 58, and this is the core requirement that I alluded to earlier that changes the level of MEPA review needed for projects located near EJ population. It essentially requires that lengthier EIR review process, and indeed the legislation uses the phrase an EIR shall be required for projects that are located in what's referred to as the designated geographic area around EJ populations. So that is either 1 mile of an EJ population or 5 miles if the project impacts air quality. We've defined that phrase in our regulations now that impact air quality to mean that either the project meets or exceeds one of our air thresholds, or for stationary sources, or for mobile sources is anticipated to generate 150 average daily trips or more of diesel generated vehicles. Now, the law also uses the phrase likely to cause damage to the environment. So this new EIR requirement applies to projects that are quote unquote likely to cause damage to environment. However, this is a direct reference to MEPA regulations where we have essentially defined our review thresholds to mean levels of impacts that are likely to cause damage to the environment. So we've read this language to mean that any project that exceeds any of our existing thresholds, either ENF or EIR, must undergo that EIR process if it's located in those geographic areas around EJ populations. However, we have also made clear that we don't read this language to require more projects to be filed at MEPA because it did not change those basic jurisdictional requirements of agency action and exceedance of MEPA regulatory thresholds. So the project must otherwise be required to file with the MEPA office and meet those jurisdictional rules. But once the project is filed, it now is kicked into the EIR review process if it's located in these geographic areas around EJ populations. Now, once the EIR is filed, the climate law also prescribed what that EIR must contain. So it's a two-step process. The assessment must contain both an analysis of existing conditions in the EJ population and whether there's an indication of an existing unfair or inequitable environmental burden or related public health consequences. And if there is an indication of such a burden, the EIR must also address whether the additional impacts of the project may cause a disproportionate adverse effect on the EJ population or increase or reduce the effects of climate change. So all of that I'll get into more detail as I go through the protocol in a bit. Next slide, please. All right, now finally, Section 60 of the legislation sets out public involvement requirements and requires the Secretary of EEA to enhance public involvement opportunities for EJ populations. And so I will explain in a bit more detail when I get into the the public involvement protocol, how we have elected to implement this section of the law. Next slide, please. All right, so moving on, I will now preview both what is in our regulations, our regulatory approach to implementing the new legislative mandates, as well as those two new protocols. So in terms of the regulatory approach, the first two bullets here refer to those mandated components of the law. So number one, of course, we have incorporated that so-called EIR requirement using that phrasing, the EIR shall be required from the law. So if a project that is otherwise required to file with MEPA is located within those designated geographic areas, either 1 mile or 5 miles, it is now required to file an EIR. We've also defined in regulation what that EIR must contain. Again, that two-step assessment of existing environmental burdens and public health consequences, as well as an assessment of whether the project will cause disproportionate adverse effects or exacerbate climate risks for the EJ population, as well as mitigation in Section 61 findings. The last two bullets here, however, refer to areas where the MEPA office does have some discretion. So one is in the area of review procedures. What are the appropriate types of review procedures that may be warranted for these new types of EIRs? We are cognizant of the fact that this new EIR requirement does extend the review process for a vast majority of our new project filings. So we did compile some statistics and our estimates based on the last 2 years of filings is that about 80% of new project filings fall in that so-called ENF only category, where the project is exceeding only those lower level ENF thresholds, but nonetheless would have to undertake an EIR process if located near EJ populations. We're also cognizant of the fact that we often get very, very small projects that may in fact have very small impacts and may not cause issues of concern and may be shown to definitively not have disproportionate adverse effects on EJ population. So in light of those two factors, we've elected to add two streamlining options for those projects that are required to go through an EIR process solely because of the requirements of the new law. So those two options are either the single EIR process, which as many know are already have already been part of the MEPA process for quite a while. So this allows the proponent to file an expanded ENF filing with a request that a single EIR be submitted rather than the typical draft and final EIR. So the single EIR would undergo one comment period and review period. A second option we've added is new. It's something we're calling the rollover EIR. This is something that we've adapted from, again, a pre-existing provision that was applied when a project went from a draft to a final EIR. So under the prior rules, if a draft EIR is filed but is otherwise complete, there are no issues remaining to be scoped and all the issues have been resolved, there was an option for the secretary to elect to simply publish that draft EIR as is as the final EIR in the next available environmental monitor. So hence the term rollover. We're rolling the EIR over into the next environmental monitor without the need to prepare another document. So we've adapted that concept to the context of these new types of EIR. So in this instance, a proponent, if the project is required to file an EIR only because of the climate legislation, you have the option of filing an expanded ENF and requesting the rollover EIR provision. There's a new checkbox that's been added to the ENF form, but we are also asking that the proponent file what we're calling a proposed EIR. So it's a dual filing, expanded ENF plus a proposed EIR. So practically speaking, I think the expanded ENF will be fairly small. You know, it's largely limited to the ENF form and some narrative, but the bulk of the project itself and all of the details of the project will be laid out in that longer proposed EIR document. It should follow the form and content in the EIR section of the MEPA regulations, and otherwise include all of the required analyses under 4 EJ impacts that is now prescribed by the climate law. So based on a review of that proposed EIR, again, if all the issues are resolved and the criteria that are set out now in our regulations are met, then the Secretary will have the option of rolling that proposed EIR over into the next environmental monitor without the need for the proponent to prepare an additional document. So again, those are two options that are available. I'm sure I'll have some questions on this later in the presentation. I want to emphasize that the rollover EIR is intended for those projects that clearly show that there are no issues of concern and there will not be any disproportionate adverse effects on the EJ population and may in fact be benefiting the EJ population. Okay, and lastly here, the regulations also incorporate key elements of the public involvement protocol, including this advanced notification requirement, which we've added, and I'll get into in more detail in a bit. Next slide, please. Okay, so moving on to the two protocols. One is the public involvement protocol. This is, as I alluded to earlier, implements that section 60 of the climate legislation. Now, the key thing I want to say here is that we have elected to take a broad approach to outreach and community engagement. This was at the strong recommendation of the MEPA Advisory Committee and the input from the stakeholders in that committee. So while that section 60 talks about whether the project will have a negative effect on EJ populations, we think the law indicates a broad intent to enhance opportunities for public involvement for all projects that are located in those designated geographic areas. There was also a robust discussion at the advisory committee about projects that have project benefits or that may be viewed as having a net benefit for the EJ population. And there was a strong recommendation and view, and I'd say it's a consensus, it was a consensus view, that even those projects be required to enhance opportunity. So it should not shortcut those opportunities for involvement and public participation. So for that reason, what we have said, what we're saying in the public involvement protocol is that all projects that are located in those designated geographic areas, either the 1 mile or the 5 miles, if it hits those additional thresholds for air quality, must undertake measures to involve EJ communities prior to filing with the MEPA office. The one exemption is a project that is proposing one single family home. So not a subdivision or a single family division real estate project, but one single family home. Now, I will say that the protocol is not particularly prescriptive of the specific measures or strategies that must be followed. We are granting some discretion to the proponent to determine the level of outreach that may be required based on the complexity and details of the project, perhaps working with local officials to do so. The one requirement that is prescribed in the public involvement protocol is the advanced notification requirement that I alluded to earlier. This is a requirement that the proponent give a minimum of 45-day advance notice to EJ communities prior to filing, and no earlier than 90 days. So we have attempted to make this advance notification as simple and clear as possible. We do recognize that that will add to the permit timeline. So what the process is that we will be providing what's called an EJ reference list. This is a list that has been compiled by our EJ director of local community-based organizations and tribal organizations that we are asking the proponent to notify. This is, it should be a starting point. The proponent should also conduct additional research with input from local officials or other sources of additional groups or additional neighborhood organizations that may be interested in the project. We have established a new email box, MEPA-EJ@mass.gov. That's MEPA-EJ@mass.gov. And so if the proponent sends an email with a request for the EJ reference list, you should include the project address and all municipalities, including within that designated geographic area. So you should identify what that area is and all of the municipalities. And we are committing to providing that list within 1 to 2 business days for purposes of engaging in that advance notification. So that is the one requirement that is prescribed. I want to emphasize that the advance notification is not intended and should not stand in as a substitute for actual engagement with the community. So we are, the whole purpose of the protocol is to incentivize and to encourage proponents to engage with the community. And so if it is clear upon filing that the project has taken no steps to engage with the community prior to filing, there is a provision in our regulations to allow for rejection of that project as incomplete for failure to meet that key component of the public involvement protocol. The last thing I'll note here, or a couple things I'll note, is the protocol also has a provision for the EJ director to communicate back to the proponent. So upon receipt of the advance notification, if there are particular types of projects that the MEPA office together with the EJ director feel it should be subject to a higher level of engagement and perhaps the establishment of a formal public involvement plan, there's a provision for the EJ director to notify the proponent and request a pre-filing meeting as well to discuss specific strategies. So there's some discretion and flexibility there to prescribe additional strategies, but otherwise that the specific content is being left to the proponent. And then finally, language services should be provided. Now, there's been some confusion on this point based on some recent questions that we've received. So the one thing I will say here, just as a practice pointer, is when a proponent goes to check that EJ mapper that's used to identify the EJ populations, I would just advise that you use the language tab. It's called the Language Spoken in Massachusetts tab. And the language information, unfortunately, right now is available only at the census tract level. So the easiest way is to turn off the EJ layer and just look at the census tracts that are within the designated geographic area. And it will tell you all of the languages that are associated with residents that do not speak English very well. And it'll identify the specific language at a 5% threshold, so 5% or more residents speaking that particular language. And so those are the languages that we are requiring be used for purposes of outreach. So meaning when that advance notification goes out, that form should be translated into all of the languages that are indicated on that map. We've also boiled down the notification to a form. It's called an EJ screening form that can be used to provide that advance notification. And it's up on our website on the MEPA forms page. We are taking steps to translate the bare bones of that form into multiple languages. So that should be available on our website as a service as well. All right, next slide, please. Okay, so moving on to the second protocol here, this is perhaps the more complex one. So this protocol relates to how to analyze impacts on EJ populations, again, implementing those prescriptive requirements of the climate legislation. So the analysis, as I stated earlier, should take a two-step form. So step one is assessment of existing environmental burdens. Now, the climate law, if you read the language of the climate law, it refers to what appears to be a quite complex assessment of both historic and current activities based on private, industrial, commercial, state, or municipal operations or projects to determine whether an unfair or inequitable environmental burden may be present. So we are not presently requiring that type of individualized assessment, which some have pointed out do not appear to have any time restriction for historic activities. However, we are pointing to publicly available data sources that could be used to assess those existing conditions. This is similar to the approach that's taken by other states like California and more recently New Jersey, as well as US EPA, which has developed mapping tools to essentially assess the level of existing burdens based on a variety of environmental, socioeconomic, and public health factors. So Massachusetts does not currently have such a mapping tool, and this is very much an area where we are watching that Mass DEP cumulative impact analysis process. So DEP just completed their 5th stakeholder session, and they've started to map out a long list of socioeconomic, environmental, and public health factors. So we're hopeful that through that process that more perhaps quantitative approaches can be developed to develop a broad screening approach that could be applied in other contexts like MEPA. However, Massachusetts does not currently have that type of approach. So what we're asking proponents to do is to look primarily at this DPH EJ tool that is available publicly. The vulnerable health EJ criteria is a key component. So those are 4 health criteria that were intentionally chosen both because they have been shown to be closely linked to environmental factors based on the scientific literature and have been shown to be closely correlated with income and racial disparities through scientific literature. So these are 4 key criteria that should be consulted. Now, due to privacy issues around health data, these criteria are not available at the census block level. They are only available at either the census tract or municipal level. However, we do think these are important criteria to consider. And so if a municipality that contains the EJ population of concern is being flagged for vulnerable health criteria, then we're asking proponents to take that into consideration and draw the conclusion that there could be a likelihood of an inequitable effect in that population. We're also asking that the additional mapping layers be consulted. So there are a variety of layers available in the tool, including, for example, other existing air and water permitted facilities, 21E sites, toxics users, proximity to large roadways and highways, et cetera. So it's, again, we do not have a clear mapping tool for screening purposes, but these are layers that are available that could be used to survey existing conditions in the EJ population. Secondly, in order to assess the climate risks, we are pointing to that RMAT climate tool that's already part of the MEPA process. The output from this climate tool is already required as an attachment to the ENF form. And we are asking proponents to assume that if there is a high risk that is flagged for either sea level rise or for extreme precipitation, either urban or riverine, in an EJ population, that could be an indication of greater vulnerability to climate risks by the EJ population. And finally, we're pointing to the EPA EJ screen. That is an off-the-shelf tool that is available. Now, they do have an EJ index that is in the EJ screen, but because those indices do not align perfectly with the definition of EJ population in Massachusetts, we're asking that proponents not use that. However, the raw environmental data and indicators are available at the census block level, and they are compared to statewide. So you can easily tell if a particular census block is 50th percentile or over as compared to statewide average. So that is a good tool that is available. It's not mandatory, but we are offering that as a resource for proponents. And finally, any issues that might come out of the community engagement process. This was a strong recommendation by advisory committee members as well, but that should be considered seriously as indicators of perhaps existing burdens that may not be reflected through data sources, but is being reflected through comments and concerns raised directly by the community. Next slide, please. Okay, and then moving on to step 2. So this is where, after conducting that survey of existing conditions, the project would then assess whether the additional impacts of the project may cause a disproportionate adverse effect. Now, understanding that's not a defined term and it is a complex issue to consider, I think we would could point to 2 key factors here when considering disproportionate adverse effect. One is whether those existing burdens that were identified in step 1, whether the project will materially exacerbate those existing conditions in some fashion. So the purpose of the survey is to assess whether there's an inequity in the EJ population, meaning there's a higher burden of some kind for these various indicators. So in step 2, the exercise would be to assess whether the nature or the severity of the additional project impact would materially exacerbate those existing conditions. The second key factor is to do a simple comparison of EJ versus non-EJ population based on the project impacts themselves. There are other programs like federal MEPA that does engage in a disproportionate adverse effect analysis. Much of that analysis is focused on this point, on this number 2 in this list, which is to look at the project impacts themselves. I think the unique aspect of the Massachusetts law is to add this component of existing burden. If there's an indication that there is an unfair or inequitable burden already in the community, then the concept is that the addition of the project impacts could be viewed as a disproportionality in and of itself because you are adding to those existing conditions. So those are the 2 key factors, the 1 and 2, I think that should be considered most prominently. Now, number 3, project benefits can be considered. However, one thing I will emphasize here is that we are not likely to accept a net benefits approach where a project that is adding significant and new impacts and pollution to an EJ population could be viewed as simply netting out those impacts through other more generalized project benefits like economic development or job training and the like. So I think the focus here would be on benefits that perhaps would reduce those existing burdens in some fashion, or maybe adding environmental benefits to the EJ population. And that aligns with the broad concept of environmental justice principles that's also laid out in the climate law that talks about an equitable distribution of environmental benefits and burdens. And then finally, a consideration of climate change effects. I think the analysis here will largely follow existing protocols around both GHG mitigation, greenhouse gas mitigation, as well as climate resiliency. Some of you may have noted that we are asking for a GHG modeling and analysis for certain types of projects, even if they're not hitting mandatory EIR thresholds, if those projects involve buildings that are likely to be used or occupied by EJ population. And then finally, mitigation if disproportionate adverse effects are identified. Okay, next slide, please. All right, so I've said a mouthful here and a lot of content. So just reviewing the schedule here, where we've been and where we're going. So we formed that advisory committee in the fall, as I mentioned, and we finalized our regulatory review process, the phase 1 process. But we are very much engaged in our second phase effort, and I encourage all of you to attend our MEPA Advisory Committee meetings, which are open to the public, and we're following that Mass DEP process, as I indicated. Next slide. So these are just ways to participate. So our advisory committee meetings are open to the public. As I indicated, you can sign up to receive ongoing updates. And of course, our website will be updated consistently. And as I noted, all of those forms, our new ENF form, the EJ screening form, is all up on our website, and we are intending to provide translated versions of them shortly. So I will stop talking now, and thank you again for the opportunity, and looking forward to having a good Q&A later in the presentation.
Great, thank you so much, Tori. A lot of good content and links in there. Again, these materials will be made available, and as Tori indicated, that presentation is already on the MEPA website. Is that right,
Yep.
Tori?
Yep.
So all those links, all that great information is available. Thank you for walking through all that. And I do see some questions starting to percolate in the chat. Again, we are going to turn to those after both presentations. So to complement Tori's presentation on the new EJ regulations and protocols, we have AJ Jablanowski of Epsilon Associates to give a consultant's ground level insight into the mechanics and obligations of the new regulations. AJ is a principal and professional engineer with Epsilon with 30 years of experience as an environmental consultant. He has a long history of working through the evolving requirements for environmental justice, including the enhanced outreach and impacts analysis to satisfy the requirements of the 1994 federal executive order, the EA's own past 2017 policy. And in addition, particularly relevant for this program today, AJ is in the process of completing 3 MEPA filings that are subject to the new environmental justice protocols. And in his preparation for the program, AJ realized that it would be good to provide some comments on the baseline health analysis and the use of the DPH tool that Tori was just talking about that's incorporated into the second EJ protocol. And so as he does with his permitting work, AJ is going to call on Joe Sabato from Epsilon to provide some comments on those issues, and I'll turn it over to AJ. And AJ, you can bring in Joe when the moment's right. So thanks very much, and we're all set to transfer over to AJ.
Okay, thank you very much. Yeah. Normally, we would be doing lots of prep and presentation for this type of thing, but it did sound like a lot of what we were trying to get across was the in the trenches set of context as to how this is working for the first few projects out the gate. So rather than giving you a really polished presentation here, I've actually been mostly working on some of those filings and having some of these draft analyses on my desk here. So I am hoping that that is going to be useful information for everybody. I do know that we probably have a lot of questions for Tori and members of her team, many of whom are on today. So we won't take too much of the time here, and hopefully leave some good time for robust discussions at the end. So broadly, yes, this is new. No, this is not new. This does build on things that really started in 1994 at the federal level and then moved on through a significant amount of Massachusetts precedent. We can go over how this looks like some of the things we have seen before. And it does break out broadly into 2 key pieces, outreach and analysis. You're going to hear me say several times to allow more time on that outreach. And I'd love to, in the discussion, get to what that means for a project, what that means for paying attention early on the project. And then when we move on to the analysis portion, we'll give a little bit of an insight as to how that's been working so far on preparing the baseline evaluations, how it's similar to things we've done before, and how it's new. And then what's really going to be important for Tori and her team to take a look at is when we go forward with a project, being able to have that on the analysis in context and seeing what sort of comparisons we're going to look at. There are many points here that are going to be topics for discussion. I do have some of those highlighted as we go through. New and not new. The 1994 federal order has some of the key words that keep coming back in this type of analysis, and that's disproportionately high and adverse. And that is a lot of what the focus here is. Might not be the exact words that have moved forward through, but that intent to try to find those impacts and avoid those impacts have been really the focus of environmental justice analysis all the way through. A lot of the reason why people did not see this in 1995 is that the initial federal EJ order was broadly taken by the federal agencies to be more associated with rule making than with actual permit issuance. So, you know, I got federal permits in the 90s without knowing of the existence of this rule. By the time we were in the 2000s and the 2010s, it was clear from the EPA side that they wanted to see something done, especially in the 2010s, for a specific prevention of significant deterioration, essentially a major source air permitting project. And so we have been through a few of those with Mass DEP at the Massachusetts level. Examples include MIT repowered their combined heat and power plant online. That tripped over the need for a federal permit. That tripped this requirement. We went ahead and satisfied it with enhanced outreach and with enhanced analysis. That broadly looks like what we're talking about for MEPA now. Similarly, with the medical area total energy plant, METEP, in the Longwood medical area, when they upgraded their combined heat and power facility, and similarly a power plant in Exelon West Medway. The 2017 EEA policy also had enhanced outreach and enhanced analysis, and we certainly took a look at that. We would be going through, essentially, there were 25 or so bulleted items, much of which was instructions from EEA to its sister agencies or other parts of Massachusetts government as to what to do, but what would apply to an applicant would be 15, 16, 17, agency public involvement, enhanced public participation, enhanced analysis of impacts and mitigation. We did have at least one project, possibly two or three, that triggered that bullet number 17. We took a look at that there. And then, as Tori expertly pointed out, the Massachusetts climate law has some key provisions that required enhancement of this. I do have to congratulate the entire MEPA team on getting something pretty coherent out by January of 2022 and here for us to implement. So that was a tight time frame, but we were building on things that were already happening. So we do very much appreciate the fact that it's here and it's legible and comprehensible. But there will be some questions in the details on implementation. This isn't happening in a vacuum. There is federal movement on environmental justice, much of which does mirror what we've been talking about here. Strengthening enforcement of violations is something that they are focusing on. Assessing impacts to tribal communities is in there. And then affirmative steps for early and more frequent engagement. And we're not the only state that is going through some of this. I am working on a project in New Jersey right now One of the key things that's different there, first of all, they're not quite as far along on their rulemaking, although they have an executive order requiring some additional comment period for projects within their EJ areas. Their mapping process is fairly similar to what we've seen in Massachusetts. What they don't have is the 1 mile and the 5 mile boundary. So the project I'm working on is essentially retiring a coal-fired power plant, but we need to put in some gas-fired capability in order to meet some steam needs. So we do need an air permit, and we're not subject to the extended comment period because we're not directly in an EJ area. We're next to one, but we are not directly in an EJ area. I'll have more time. On the outreach, Tori gave a great set of descriptions of the expectations, and we do want to, and we do have some questions. I'm sure I have some questions of my own about how best to do that. But people who have been going through the MEPA process, if you've gotten a certificate within the last 12 months easily, much of what we're being asked to do in this policy and protocol was already in your certificate. So, you know, I'm looking at a February 2021 certificate, and the overlap between what we're being asked to do there and what we're being asked to do in the January of 2022 protocol is remarkable. So, please do go ahead and follow the instructions and get that list from EEA. And one of the things you'll want to do is allow some time to take a look at that list and to come back to Rishi and Reddy and her team with any questions regarding inclusion or exclusion of people from that list. And then realize that there are similar wheels in motion at Mass DEP. So if you're in MEPA because you're going to be triggering a Mass DEP permit, and Mass DEP is going to want you to do enhanced outreach associated with their project, and with their permitting process, it may make sense to take a breath, find out what Mass DEP is going to expect from you, and cover the outreach in a coordinated approach. We have a project right now. We got a list from EEA, and we also have a list from Mass DEP. And we have a draft public involvement protocol along with recommended notifications there. And there's overlap, and there are gaps in between the two, and some coordination between those two things is important. Tori also mentioned about going beyond the list. I mean, the folks at EEA are doing a great job with what they can but they do not know every community in Massachusetts, and they do not know every neighborhood in every community in Massachusetts. Which would go right to the next bullet there, finding the right people at town government and asking them the right questions. In this town, in the city, there is somebody who knows who you ought to be talking to if you have a project in a particular neighborhood, and want to reach the people who are going to be impacted by the project and educate them to what your impacts are and what the project is, so that they are not surprised later in this process, so that they have the opportunity to learn about your project and provide input early in the process. But it can take some time to find that right person. And it can take some time to have that person fully understand what you're asking and why you're asking it. This is a new thing at all levels, and coming in and saying, I really want to know who the community groups are, who the active individuals are, how I would get information to not just the town, but this neighborhood in the town. Those could be new questions. And, you know, the right person to answer them might be in the mayor's office. The right person might be in the economic development, it might be in the town clerk. It can take some time to find that person. And then going beyond the newspapers and reaching people actually affected. Now that's where there's a lot more guidance in the recent certificates. There's a lot more guidance in the current protocol than we've had previously. A lot of the, you know, MEPA has always been tell people about what your project is, but it's been more of a in the legal ads, you know, get a newspaper notice in the legal ads, document that you noticed it, rather than an informal effort, which can be something more like an announcement on radio, or if there's a bulletin board at the donut shop in the area, and you know that's where the dog sitting announcements are, that might be what people are reading. So finding the right locations there and getting that information out in those sorts of manners, those are the types of things that is our understanding the MEPA office is looking for, and can really hit the main goal of this, which is to get to where we are reaching the people who would want to know and need to know about a project in the community. This is what the maps looked like in 2010. This is what the maps looked like in 2020. Looking into the weeds on some of this, if you've had a project that's been going over the course of 2021, the maps changed on you, and you ought to go ahead and check to make sure that the same impacts, the same areas are affected. They did not necessarily, if you take a look, the total areas are not that much different as far as surface area of the Commonwealth of Massachusetts. But we had one potential project location that went from an EJ area to not an EJ area. And we had another one where some of the census BLOS groups within a mile got added based on the changes in definitions and the changes in data. Language. Tori did talk about language, and one of the things that's taken a little while to fully disseminate here in Epsilon is this will probably be something to go ahead and have some discussion on during the comment period, but I'm counting currently really 3 different language isolation thresholds right now. If a community has more than 25% not speaking English very well, it turns into an EJ community all by itself. But you have to look past that. Tori mentioned the 5% threshold where you really ought to be translating and providing language services. There's also been some discussion about a 10% threshold where that might be tied to an assumption that somebody is interested in the project who doesn't speak English very well, and needing to make sure that you are all the way ready to communicate with that person when she or he appears. That is something I'd love to discuss during the chat some more. Allow more time. When we did the MEPA public meeting, it was announced in a couple of different languages, including for that area, in the Longwood medical area, it was announced in Russian. There is a Russian newspaper serving Russian speakers in that part of Boston and Brookline, but it comes out once a month. So if you want to have a notice in that once a month newspaper, you can't call them up on a Friday and expect it to be in on Monday. So that's the type of thing where 45 additional days might not be enough on the front end to be all the way ready to tell people about a project. We did do the MEPA public meeting associated with the hearing at a hotel conference room. It was, in that case, pretty accessible to the people in the area, but not all of these environmental justice communities are going to have an appropriate hotel conference room to hold a meeting in. Hotel conference, the hospitality industry is ready to help put a meeting together and has a conference room that you can pick up the phone and rent within 5 minutes. And you know about what it's going to be. You know that there will be staff. You know that there will be a sign to point people towards your meeting. You know that there'll be a certain number of chairs and bottled water and bad coffee at the back of the room, and will generally be all set for you. If in a hypothetical example, you've identified in conjunction with the city the fact that you have a community college in your environmental justice area, and they have a gym that might be an appropriate location. It might take a week between contacting the general number and finding the right person to say, yes, that there is this process to rent out that gym for an evening. And it might take another couple of days if that's a community college that's a new campus and it happens to be a former Catholic high school and the ownership still rides with the archdiocese and there needs to be permission associated with that. And there are a lot of ways where those sorts of preparation steps can take more time. So engaging early and telling a good story early is going to be important. This is another example, not an EJ outreach at all, but we had a client who had a power plant they wanted to put in a town that said, you can't even begin to put in a power plant until you get a two-thirds town vote. So the very first thing that they did really was announce it and set up a science fair type presentation to say, this is what it's like, this is where it would be. And with that experience, we were able to communicate with a lot of different people and explain to a lot of different people what would end up being happening. A lot of the questions that get asked in that sort of situation are these hypothetical questions. Well, no, are these serious questions from the people in the community that you don't yet have the answer to. What will the air impact be? What will the noise impact be? What will the traffic impact be? So if you were getting out early and answering some of those questions, it has to essentially be in the conditional case. You're essentially saying, well, this is how we will analyze that. This are the standards that we're going to compare against, and then these are the regulatory processes where somebody is going to review those standards and say, yes, this is okay, no, this is not okay. Translation services, there are a lot of ways, and it's not that hard to take a 2 or 3 page fact sheet, especially if that's already been turned into something that does not have a lot of jargon, as it should not. That can get turned around pretty cheap and easy. Taking an entire EIR filing and translating it would not be. When you talk to the translation firms, they will start to ask questions that the website might not give you an answer to immediately. Once, if the language is Chinese, well, what is it? And what written language ought to get used? If you're triggered for Portuguese, is it really Portugal Portuguese? Is it Brazilian Portuguese? Is it Cape Verdean Creole? That's where some knowledge of the community can be helpful. And that's where I'd be curious again to hear from Tori and her team a little bit on how much detail does that need to be drilled down Interpretation, again, I'd love to have some discussions with the group about how that ends up working. We have done a lot of outreach on some of these prior projects. I honestly look forward to the first day when somebody walks in who isn't speaking English or isn't speaking English well, and we're able to help him or her. It has not happened yet in my personal experience. We've had live interpreters for possible languages who get a little bored at some of these meetings, and it may be helpful if we can sort out beforehand when they might not be written. If there's a way to make sure that people can request their presence early, or if somebody walks in and can't speak the language, there are services you can get to on a speakerphone that may be able to help with that. Again, something to talk about. This feels like it's an opportunity to tell a good story, and clients generally proposing good projects, and we really should be telling that good story. And but those clients need to pay attention earlier than they're used to doing. Lots of times, very early on in the project, the developer is very busy putting the pieces of the puzzle together, getting their financing, getting the major equipment, getting the preliminary design pushed forward, uncovering and the roadblocks and fixing the roadblocks. They also want some schedule certainty. So allow more time. Let's talk about what allow more time means when we get to the comment period, which I should hurry up to make sure that we get to. A little more quickly now, outreach and internet, Facebook and other places are useful to let people know that you're going to have a meeting, let people know that you're going to have a conference like this or a live meeting like this. Getting into back and forth online is not necessarily going to be a useful use of your time. It's been brought up a couple of times that a fact sheet with a QR code can be helpful for people who are now with menus getting used to flip open your phone, flash it at the fact sheet, get to the relevant information, which means, of course, that you have to have a project website ready to send people to that can tell them what they need to know. The fact sheets that are going to be an important part of this are also not new, but they need to be tailored to the specific situation. You can find Mass DEP has posted easily 20 different fact sheets for approvals that they've done in the last year or so. Those are focused on how Mass DEP has set up the impacts and the project descriptions and so forth, but they are a reasonable starting point and example of where you go from there. The fact sheet that we should be looking at for this is going to include what the MEPA process looks like and how to comment in that MEPA process. When you're writing a fact sheet, we need to have it, taking what can be a 500+ page environmental impact report and distilling it down to what somebody might reasonably read, which really is going to top out at maybe 3 pages or less. And it really wants to be readable. Microsoft Word has readability statistics right in it. So when you're drafting, there is this less Kincaid grade level and reading ease. And Microsoft these days will go ahead and give you wording suggestions to try to simplify your language. Clearly, any jargon, any acronyms need to be spelled out. And if you've got somebody on your team that has no idea what the project is, I would recommend handing the fact sheet to that person. And if they don't understand what you're saying, you didn't explain it well enough. On the outreach, I do hope that we get to talk about GHG. Tori mentioned that a little bit there. CBOs and tribes in the reference serving as a resource to solicit feedback. I'd love to see if we can get into some discussions about how we can have useful conversations with actual people potentially affected by a project, and not and make sure that everybody is being constructively engaged on both sides. And then there is this form that Tori alluded to. These are a couple of pieces on this form, including things that might be a little bit hard to really hit the nail on the head at the very, very beginning of the project. So again, things I'd love to talk about. But that's only half of what we're doing, so I should really hurry up. Analysis, what does it say and what does it mean? And Joe, I think I took up too much of your time, but I am going to go ahead and hand it over to you for the next few slides.
Sure. Thank you, AJ. Broadly, Tori did a great job sort of outlining the process that someone would go through in order to determine the impacts from a project. And if you look at the diagram on the right-hand side, this comes from risk assessment, where you're looking at really the middle of, well, what is the vulnerability of the population in terms of their sensitivity, and that's kind of what the vulnerability analysis, the burden analysis is getting at. And then you're looking at your project, which is the potential hazard, right? What is your project adding to sort of the environment? And lastly, what are the opportunities for exposure? And really this MEPA protocol is getting at that center part, which is what is the risk to the vulnerable population from exposures to hazards from your project. All right, so that's how I sort of think of this process in terms of MEPA's protocol. All right, AJ, next slide. So determining the existing burden has a sort of a multi-step process. Tori mentioned this designated geographic area. That involves looking at the site boundary of your site and then looking at either a mile or 5 miles, depending on what you're required to. If it's a mile, you look at any environmental justice population within that mile. And even if it only sort of just catches the edge of that census tract, it's included in this burden analysis. So you end up with environmental justice areas that may extend beyond that mile radius or 5 mile radius in some cases. The Mass DPH environmental justice tool has a number of different criteria which use this vulnerable health environmental justice criteria. We'll talk about that more in a moment. And then you use that same tool again to go through a series of layers within the tool to try to identify, what are the number and types of facilities, what is the compliance history associated with those facilities, and ultimately, are you in an area where there's lots of compliance or lots of non-compliance? There isn't really any criteria for that second stage for how to evaluate those additional data layers. The RMAT tool is another portion of this burden analysis, the EJ screen, and then lastly, during this public health outreach, the public outreach, trying to listen, right? What are the existing challenges that the communities are dealing with? What are concerns that they're worried about? And trying to make sure when you have those public meetings that you're really targeting to make sure that that's information you're absorbing and you're addressing as part of your analysis. And that to me is something kind of new that's come out with the outreach protocol that MEPA has prepared. Next slide. All right, there we go. So again, we've been using this tool. This is sort of the page right now. It's under maintenance. It's been under maintenance a few times over the last week or so. What we're seeing is each time it goes under maintenance, it seems to have some kind of new feature, which is kind of cool. So But again, it's just a point to start these analyses early. Next slide. So within the tool, you'll notice that there's sort of two different ways you can access the tool. One talks about sort of these presented on a community basis kind of level. And you can toggle either whether you're interested in the environmental justice sort of data, whether it's a minority population, how many people live within that census tract within that community, or what is the vulnerable health data associated with that community. And again, you'll notice that this is the intent for this tool is one of sort of many things you consult as part of doing this analysis. Next slide. So what are the vulnerable health indicators? There's 4 of them. Really for all of them, they're focused on what is the most recent 5 years. There's a heart attack hospitalization rate, and that is looking at the age-adjusted rate of heart attacks, and specifically a community or is considered vulnerable if it's greater than 110% the state rate. Similarly, childhood blood lead levels, again, it is considered a vulnerable community if blood lead levels at the census tract level are greater than 110% the state prevalence. Next slide. And then there's low birth weight and childhood asthma, again at 110% statewide rate. Next slide.
Hey, Joe and AJ, just letting you guys know that you have about 10 minutes left.
Great. So a little bit of a busy slide here, but I'm going to take a few minutes to sort of walk through what is this type of data that you're presented with when you sort of drill down this information. So one of our projects happens to be looking at the Taunton area, and you'll notice in the table, one of the things that we're talking about is the heart attack vulnerable health criteria, and that is available at the community level. So this is a rate for the entire town or city of Taunton, and that is 31, and that's usually 31 per 10,000. So that's 31 cases per 10,000 people is the rate. The confidence interval is a measure of of the variability of that rate. So the rate, and that's a 95% confidence interval. So we're pretty certain that our rate is going to fall somewhere within that range, okay? And then you'll learn something about the statistical significance of that rate, okay? Whether we have enough cases that we can be, and that this comes into when we're comparing to the statewide rate. So if you look 2 columns over, the statewide rate, again, it's 26.4. You'll note the statewide rate is less than the community rate, right? And then you'll notice the statewide rate confidence interval is between 26.2 to 26.6. And that confidence interval is outside the community confidence interval. So what this is telling us is that the Taunton rate of heart attacks is statistically significantly higher when compared to the statewide rate, okay? So all of that is pretty useful information when I'm looking at this data to try to put it into context. For MEPA's purposes, if you are greater than 110% of the statewide rate, it is considered a vulnerable, meeting the vulnerable health criteria for that health endpoint. You'll notice in some cases, so for example, low birth weight. Low birth weight has at the census tract level, it is not statistically significantly different from the statewide rate. And often that can be a sign that we just don't have a whole lot of cases. It can be a sign that, so in this case, because the community, the rate is 327.9, and that is greater than the statewide rate of 238.5, that even though it's not statistically significantly elevated, okay, that this could just be due to chance alone, that you would be including it as a vulnerable health, as meeting the vulnerable health criteria. Okay. Lots of times this can get some rural areas with low population density into meeting the vulnerable health criteria faster. One other thing I do want to mention on this slide is you'll see one of the first steps of this process is on the left-hand side of the slide. There's sort of a map mapping out that 1 mile radius along with what block groups are sort of impacted. And that these are really the areas of focus for your analysis moving forward. Okay, next slide. Again, when you start to get into some of the other tools or layers that are on the Mass DPH EJ tool, there's 21E sites, activity use limitation sites, tier 2 reporting. There's a number of data sources, and it can take some time to sort of go through each one, identify what the site is, and then there's a separate opportunity to search for what is the compliance history associated with that facility. And again, this is more of a qualitative type of analysis of trying to understand sort of what is going on in the community, in the vicinity of your project. Again, next slide. Some of the nuances of the tool that we've been able to figure out. One, you can save your project and come back. It has a lot of similarity to ArcGIS. If you're familiar with GIS software, you can create buffers around a site. So it's just a fancy word of saying, all right, there's your 1 mile or 5 mile radius. You have the ability to be able to select information and export it out into an Excel file. You have the ability to be able to even export out shape files and import into ArcGIS for you to be able to work. And sometimes it's been a little bit easier to export the data out to work with it, as there's kind of more GIS functionality within GIS software. My one worry and one caution about doing that is with all these updates to the tool is that it may lead to accidentally using data that's been updated, and now you're using older data because you exported it out and we're working with it outside of the DPH tool. The data can be, downloaded into Excel. It is possible to do the entire analysis using the DPH EJ tool, which was something that a couple of weeks ago was not possible. You had to basically bring it into GIS. Next slide. Again, EJ screen will provide some criteria that overlap with the criteria that's within the EPA tool. It can take some time, again, to go through the individual indicators and to give some thought as to what they're showing. A lot of times it can be difficult when you're, say, below the National Ambient Air Quality Standard for ozone, but at the 85th percentile for the state, to sort of say, all right, well, is that a vulnerability criteria if we're meeting if the whole state is meeting the standard, for example. So a little bit of thought as to what you're going to do and how to explain the data is sort of required. All right, next slide.
Hey, Joe, you have about 3 minutes left.
Yep. And then next slide after this. All right, AJ, I think it's your turn.
I think this was about my handoff, and we will whip through the rest in order to, because a lot of where we go from here is, all right, well, we now have this information. What do we do with it in the context of a MEPA filing? The MEPA rules say, unless the assessment Joe was just describing shows the absence of any inequitable burden, Generally, when you are looking at this, multiple census tracts and multiple different things and multiple different criteria, something is going to pop high. Something is going to show that it's elevated. So I don't think any project is going to stop at this stage in the analysis. So now we're into two key challenges where we need to identify the relationship or the lack of relationship between the impacts and the identified vulnerable health criteria. And then, kind of look beyond what this analysis has been, the project's impacts to look at pathways that the projects could disproportionately impact other EJ communities. And there, we haven't talked about noise, we haven't talked about odor. There's the possibility, if you're using a whole lot of the wastewater treatment capacity and you've filled up the sewer lines between you and the wastewater treatment plant, are you backing up sewer, are you backing up toilets in the EJ community? You need to think about the project and its impacts. Most impacts are going to be proximity based. So if you are closer to a non-EJ area than an EJ area, you're going to be able to say that you don't have disproportionate impacts in most cases. The analyses that we've looked at in the past have generally focused on some of the air quality issues, but we are now looking more multimedia. And some of these pieces of that protocol that we got on January 1st, I do think are going to be worth some discussion in the upcoming discussion groups here. And that includes when a proponent might conclude that they have a disproportionate adverse effect on an EJ population. What are the circumstances where that might happen? What are the circumstances where either MEPA or the relevant agencies or the proponent might say that we are materially exacerbating an existing burden? Love to talk about greenhouse gas if we have time. And then if you are materially exacerbating an existing unfair burden, the way this rule says, that does not mean that you stop and don't have a project. It means that you need to propose measures that are in addition to those already taken to avoid, minimize, and mitigate the environmental impacts. And I'd love to hear some discussion about already, if you're already proposing everything that's feasible, what are you supposed to propose in addition? So that kind of goes into my question list, and I strongly suspect that that the chat bar and other people on the meeting notes here on the meeting will have some of their own. So I'd love to hand it back for moderation at this point and say, all right, well, based on what we've talked about, what questions do we have from the MEPA office?
Thank you, AJ, Joseph, and Tori. That was excellent and very informative. I know I learned a lot. I'd like to start by asking our panel to describe what a good EJ outreach process looks like, both from the perspective of the MEPA office and then AJ from the perspective of the applicant.
Yeah, thanks. I can say a few words. And AJ, we appreciate your very detailed presentation there. I learned some too, just by you're walking through that. I know we've worked with you on some of our EJ related projects, and your statement that our protocols are coherent and legible, not exactly a ringing endorsement, but I'll take that as a compliment. So, yeah, we did develop on very tight time frame, and I'm very open to this type of feedback, and I feel like the next few months will be a good test run for both of our protocols on the outreach and analysis piece. And I see some questions in the comment in the chat as well about this very point about what do we mean by meaningful engagement? How are we going to evaluate the quality of outreach and engagement the project proponents come in with? And that's a really tough question, and something that we batted around a lot in the advisory committee as well. And one ask, I would say, or request that came out of that discussion process is that the MEPA office itself, perhaps together with the EJ office, develop more expertise in this area, perhaps expand staffing to have more of a project liaison type of role. I know some cities and towns do it. BPDA has a pretty robust EJ program where it would be perhaps a MEPA analyst or an EJ, someone under Rishi sort of sitting side by side with the project proponent and mapping out strategies for specific projects. So we have taken that to heart and are considering those types of procedures going forward. Right now, as I stated, we're not being overly prescriptive right now. I think we're sort of putting this out there, strongly encouraging, and it's a bit of a carrot and stick. We're saying we're giving you a lot of discretion, but if you do nothing, be forewarned that the project could be rejected. And, frankly, the project may get a lot of negative comments right during the review process. A lot of the exercise here is to get out early, proactively talk with the community and people who are actually living there and affected by the project so that the review goes smoothly, and maybe it's more likely we can grant a single EIR if these issues don't crop up during the review process. So it's hard for me to say specifically what strategies are good or bad right now. I think we are still test driving this and seeing what comes in. We would love it if project proponents take this to heart and really get out there and show, kind of come in with model projects that then we can put out as examples. But I think the one key is to just truly engage with the communities. AJ touched on it a bit. I think in the past, proponents are used to just working with the local planning board, right? They'll go through the CONCOM hearing or they'll do whatever the prescribed public hearings are. But I think the concept here is to really engage directly with the community. We are talking about people who have vulnerabilities, right? They're low income. They may not have the time and resources to sit in on meetings during business hours. They may not speak English very well. So just being cognizant of those existing vulnerabilities and sort of impediments to public participation and trying to do the research of the particular neighborhoods, how they operate, are there business groups there, neighborhood groups there, and doing that advanced research and just taking a good faith effort to engage with your neighbors, before putting a project in that community, I guess is the key thing that I would focus on for now.
Valerie, you'd ask for my 2 cents.
Yes, I'd love to hear what it looks like from the applicant's perspective as well.
Okay, well, successes and not so successes. I in the past, I feel like it's been a success when we've been able to take a 500-page technical filing and distill it down to 2 pages that said, that focus on what does it mean to me, and have people read it and understand it. Because there are a lot of folks in the world who do not have the time to read a 500-page technical document, and getting to them and getting that information to them. Being able to actually have one of your neighbors come into one of these meetings and say, I heard about your project and I have concerns, and hear those concerns. Like, I'm worried that this traffic, I'm worried that you don't know that this road is already plugged on this time of day. I'm worried that you're going to have chemicals that are and being able to come back at those people with, this is how we're going to address that. Either here's the analysis that's already done, or here's the process by which that's going to be analyzed, and have them feel like they got heard. The times when it hasn't been has been honestly when there have been CBOs involved who are going to come right out and say it, more interested in stopping the project than in learning about the project. And I think an engagement plan that feels like it works from an applicant's perspective is really more focused on the first type of person than that second type of group.
That actually leads really well into my next question, which is about the list of CBOs that the MEPA office is putting together. Have all the CBOs that are on that list sort of indicated that they want to be on it and they want to be engaged in these processes? And what's the expected role of a CBO in a project information process?
Yeah, sure. We have gotten that question before. And I think we got some of that reaction because of some early efforts that we took in the projects that were filed in December, right on the cusp of the rules. We got a huge influx of projects really intentionally filed to try to get in, before the new rules came into effect. So we did take some steps to try to meet the spirit of the new rules with some expanded outreach. And we did put those lists out there probably for the first time. They were admittedly quite broad. We were still in the process of developing them. So we have gone through, actually started the process of reaching out directly to the CBOs on that list. And I will say, I'd say imminently in the next couple of weeks, we do intend to put out more refined lists that you will see are much smaller and narrower and really focused on, as you noted, the CBOs that have indicated interest in partnering with MEPA in reviewing projects. In terms of their role, it really is meant to be a resource as a starting point to engage with the actual communities who live in the community. So obviously these are organizations, so not individuals or residents, but they are organizations that have environmental justice, as part of their mission statement and are engaged in other forms of outreach, right, and have connections with those local neighborhoods. So they are meant to be a resource for the proponent to get suggestions and other ways to get the word out. But as I stated earlier, should not be a substitute for other good research that you should do directly, together with the towns or other resources to get that information. But the hope is that those organizations, depending on the project, if there's one that of concern or, they feel like warrants that additional level of effort, could be partners in doing that outreach and identifying those neighborhood pockets where you'd want to get in and do those good community meetings and engagement prior to filing.
Well, I would love to get into some of the questions that were dropped in the chat. And before we start doing that, I want to let everyone know that they're welcome to raise their hands and we can raise your virtual hand, that is. And I'm happy to call on people to ask their own questions directly. I think, AJ, you had the first question that popped up in the chat, so I'll let you go ahead and ask that directly.
That was minutes ago and I don't have it in front of me. So now we're into the question about a MEPA filing and the possibility of a rollover. In the event that you got, somebody put in for a rollover, but they drew a negative comment, that they drew a substantive comment between the draft and the proposed final, would the applicant, is that just, there's a comment letter and therefore you need to file a response, you need to file an FEIR that has some updates?
Yeah, that's a good question. And it is, so, I think the short answer is no. It's not sort of a rule of thumb. One comment letter will disqualify you from a rollover EIR. There are the specific criteria, and obviously it needs to contain the analysis that shows clearly that the project will not have those so-called disproportionate adverse impacts. So, I'll be upfront. A lot of the prior discussion with stakeholders about this rollover was really focused on projects like ecological restoration, where a project is the very purpose of the project is to improve environmental conditions in the neighborhood. So projects like that, where it's really just obvious on its face that they're not causing harm, they're improving environmental conditions in the area, and plus have done sufficient outreach so that you're not going to draw those negative comments. The quality of outreach is clearly a factor that we will consider, and we have put that directly in our regulation. So if that engagement is not done and you do draw a very negative criticism from multiple residents or organizations, I think it's going to put the secretary in a hard spot, I think, in the MEPA office in a hard spot to just simply say, okay, you can move on. So that's the kind of carrot and the stick or dynamic that I described earlier between the outreach and the quality and length of the review. I think the more time the proponent spends with the community and get that public support, that dynamic you just described hopefully won't arise, so that if the analysis is otherwise complete and it meets all of the other criteria, that we'll be in a good position to grant that rollover EIR. We also, just to clarify a little bit more, the rollover EIR does say we can either roll it over or require a response to comment document as well. So there's a slight tweak, where we may, if it's a very small issue but appears to be a one with that's strongly held, that perhaps we could just ask the proponent to respond to that comment. But otherwise, if you can prepare that response to comment document quickly, it can get published pretty quickly after the review.
So our next question comes from George Drew about whether meaningful engagement is defined and approved by the agency. And I'm going to amplify that question with, can you tie that into pre-filing meetings? So is a engagement protocol something that could be approved or at least discussed in a pre-filing meeting? And would that meeting be sort of in addition to your traditional pre-filing meetings, such that you're now having two of them, or would we be combining them such that that's happening a little bit earlier in the process than it might otherwise have in the past?
Right. Yeah, no, I would say the more the proponent can do to do that legwork, including requesting a pre-filing to go over specific strategies, I think would be helpful. I mean, someone noted that Mass DEP and other agencies are starting to have similar engagement strategies. So obviously the more buy-in you can get from that agency as well, that whatever the public involvement plan that you're intending to follow is going to comply with the regulatory requirements down the road would be of benefit. As I said, we're not currently putting out standards out there to say, here are the things that we are calling meaningful engagement versus not. As you've probably noticed in the protocol, it is largely a list of best practices. We're encouraging proponents to do that research of the community, get out there and try to identify the effective strategies for communicating with those neighborhoods. But the more, as I said, the more you can do to get that input, both from our office, the EJ director, and the agency involved, would be helpful. To that end, we are offering joint pre-filing sessions between the MEPA and the EJ office. So if a request there's a particular link we're using for scheduling. So if you send a request to MEPA@mass.gov, you'll get the link, and there's an option for joint meetings. It's going to be every Thursdays from 1 to 4 or 1:30 to 4, sorry, to again provide that efficiency of getting all that good input, both from Rishi's shop and the MEPA office as well. I guess I am hard pressed to say, we're not going to officially sign off on it, so it's not going to foreclose future comments. That's not how it would necessarily work. There is that provision where the EJ director herself could request a pre-filing and really try to establish something and put something in place prior to filing. And that would be ideal for those big projects that maybe we should have some of those pre-filing discussions. So yeah, the more legwork you can do to do that, and we are open to having those pre-filings for anyone who wants to come in and speak about those specific strategies.
I think our next question. Oh, go ahead.
Yeah, but it wouldn't be something that we would necessarily approve, and would be part of the record, as it were, before it comes in.
Our next question comes from Ashling O'Shea, looking for some clarification on the relationship between an ENF and a single EIR versus a rollover and how those work together.
Yep. Yeah, I saw that question. Yeah, so I think the easy answer here is that yes, the proposed EIR is only for the rollover option. So the single EIR is the same kind of document that was used in the past. So there's an expanded ENF filing, and then we would scope the project for the single EIR. It wouldn't come in at the same time. So in terms of the EJ analysis, if it's an expanded ENF requesting a single, we're asking that at least that step 1 assessment of existing conditions be included in the expanded filing. And then, you know, feel free to include more in terms of the step 2 project impacts, but the expectation would be that we would scope that for the single EIR. Whereas with the rollover provision, you'd have a proposed EIR that includes everything in one package.
I think we covered the next question already. So I'm going to skip ahead to Michelle Simone's question, which relates to clarifying whether the 45-day advance notice is just required for the EJ community distribution list, or whether it should be distributed more broadly to the full ENF EIR distribution list that we're more traditionally used to distributing these notices to.
Right. Yeah, that is just for the EJ groups. It's not an advance notification for the entirety, because that includes all of our permitting agencies, et cetera. So it's just for the entities that are included on the EJ reference list. The one exception is the EJ director herself. As many of you noted, the EJ office now is part of our formal distribution list for all project filings. But the email address for that is just the same EJ box that I mentioned earlier. So it's MEPA-EJ@mass.gov. So as long as you copy that box on the advance notification, that should be sufficient for purposes of the formal distribution list.
Our next question is for AJ, and it comes from Thomas Iranzian. I apologize for pronouncing that, but he wants to know how much additional permitting cost and time you would advise clients who have a project that is sited within an EJ area versus a non-EJ area.
Well, yeah, I'm going to speak in generalities on this, but we do have a situation where somebody had a gas station, which would have been an ENF only, and now, because not in an EJ area but within a mile of an EJ area, it's a mandatory EIR. And you know, and the cost, that step on our effort is really substantial. So you know, there's a 5x cost increase associated with that step right there, and that's where we are hoping to see whether or not there's an opportunity to streamline that, and you know, a year from now, when we've got several of these under our belt, we should be able to say that there's no other, you know, that here's this path that we can go through that isn't quite as expensive.
Thank you.
Well, there was a second part of that question, which is, I mean, so if you're a business person, you have a new project and you can locate it in a non-EJ area versus an EJ area, it's going to cost you 5 times for permitting costs and tremendously more timely. Why would you pursue a new project in an EJ area versus a non?
I would go ahead. I don't know about, you know, my costs and this timeline versus the overall timeline for the project, but you can go ahead and play on the EJ Mapper which not only will show you where you are, but also draw a 1 mile circle. If you're in Eastern Massachusetts, I think it's going to be hard to find a lot of spots where your 1 mile circle does not find an EJ community.
Do you have clients that are using EJ geography as a citing criteria now?
Not yet.
Okay. Thanks.
Thank you. Our next question comes from Jen Burke at GZA, asking about whether virtual meetings can be used for community meetings, or do all the meetings need to be in person?
Yeah, well, we're not prescribing in person versus remote. Again, I think that would fall under the discretion that we are kind of according to the proponents. So obviously, you know, following the best public health advice out there about the best way to hold meetings responsibly, absolutely should be followed. One note I will say on that is, as many of you know, like the MEPA office itself has engaged in solely remote consultation sessions for our site visits. We are actively considering resuming in-person site visits for at least a good portion of our projects. And part of the thinking is because in EJ neighborhoods, there might be a strong interest to, you know, actually walk the site and see the site. So that I don't want to downplay the importance of that. That definitely is a request that we often get and something that we are actively considering. So I would, you know, obviously suggest that and recommend it to the extent that's a responsible way to do it given public health conditions.
And our next question comes from Julie Holstrom. Is it suggested that any project that may be seeking state grant funds and thus constituting a state action, should this MEPA process be started prior to the grant award?
That's a good question. You know, I think it sort of falls in the camp of the additional time that this new process will take. So certainly if you need to build in that time prior to the award, that would be advisable to do. I will say that, you know, we get a lot of grant funds that do trigger MEPA review. Some of those grants are solely for design and also explicitly for permitting, i.e. getting the project through MEPA. So we don't, you know, good number of times we don't necessarily consider that to be the actual action that's triggering MEPA. Otherwise, you would never be able to get the money to go through MEPA for design and permitting. So I think that could be a good way to distinguish. You know, you can take the money to get it through permitting, but certainly once you get to construction, that does become the official agency action, and you may want to build in that time frame to allow for this process to unfold.
I have one last question about projects I see a lot that don't necessarily have a state permit at the outset, and so we don't necessarily have any MEPA jurisdiction, but then after you've gone through your local permitting process, somebody requests a superseding order, or they file, or you end up with an appeal to the Housing Appeals Committee, and all of a sudden you need to go through the MEPA process. Some of those regulatory frameworks have their own time frame. I think for the Housing Appeals Committee, right now under the regulations, you've only got 10 days to file your ENF from when the appeal is filed, which obviously is quite a challenge with the new EJ regulations, because it doesn't leave a lot of room for that 45-day advance notice.
Right.
I'm wondering if any thought's been given to how those two processes should be reconciled.
Yeah, that's an interesting question. I haven't been asked that specific question about unanticipated actions that come up. I mean, certainly appeals are by definition a little bit unpredictable, I guess. Yeah, it's hard to answer. I mean, we're not currently thinking about like exemptions, for example, for projects that have unanticipated, you know, HAC appeals or something like that. So that is certainly, it sounds like that's an additional risk that proponents will have to be aware of if you're proposing affordable housing, for example, and SOCs obviously are kind of an unexpected factor. I mean, the only thing I can offer there is that, you know, as I mentioned, we are going through this phase 2 regulatory review effort, and one of the key things that we're focusing on is to look at our thresholds more globally, because while the EIR requirement is mandatory and statutory, it does use language that refers explicitly to our threshold. So if a project is likely to cause damage to the environment as defined in our thresholds, then that's what triggers the EIR review. So there's been some early discussions about trying to look at it from an EJ angle. Are these thresholds that we have been in our regulations for many decades now, you know, is this a good opportunity to refresh those? Are these truly impacts that are likely to cause significant damage? Or, you know, are they too low in some instances because someone just decided to put them in as like a catch-all or a safety net for certain types of projects? So that's an opportunity there to really look at our thresholds more holistically. And some have even suggested maybe we should have a separate set of thresholds just around EJ neighborhoods if there are particular impacts of concern that we think should trigger the review. So those are opportunities for more of a global look, I think, at our regs. But we are cognizant of this burden. I hadn't heard the 5x number before, but we're very cognizant of the fact. And we've had 2 filing cycles now as of January 1, and I had expected a huge influx of projects. We had all of 8 projects the first round, only 4 of which were around EJ neighborhoods, and we only got 6 projects this last round. So I'm kind of assuming people are trying to figure this out and trying to figure out the new rules and determining the best course of action. So the next few months will definitely be a good preview of what happens, whether this actually incentivizes projects not to happen or to happen, and but hopefully our phase 2 effort here provides some form and opportunity to course correct and try to revise and refine as needed to get at some of these unanticipated consequences.
Thank you very much. Thank you, Tori, AJ, Joseph. That was excellent. With that, I'm going to turn it back over to Jackson to close us out.
Thanks, Valerie. Well, thank you, Peter, for putting this together. Yeah, thanks, Tori and AJ and Joseph, for your valuable insight, and thanks to everyone that attended. Obviously, there was a lot of excitement and interest in this topic, and EBC is happy that we could provide the platform for a discussion such as this, and it will certainly not be the last one, of course. So, please keep an eye on the EBC calendar for future webinars and eventually in-person conferences where we talk about this further. So there was a webinar feedback survey link in the chat. Let us know what you liked about the webinar, what could be improved, any topics of interest for future webinars. As I mentioned a few times in the chat, the presentations and the recording will be shared with attendees in about 5 business days in a follow-up email. And as always, consider joining and getting involved. There's lots of ways to do so. So we're happy to have you. Enjoy the rest of your Tuesday, and we hope to see you soon. So thanks again, everyone.